Alrighty, thank you so much for your patience. Good evening, everyone, and welcome to the ABSIP POPI Act seminar. And I hope everyone is keeping warm, safe, and healthy in these very uncertain times. This is a very great opportunity to learn about the POPI Act itself, who it applies to, and what we need to do and why we need to do it. My name is Prudence Makulolo, the Deputy Treasurer General of ABSIP, and joining me tonight is Apindile Govuza, who is a Senior Associate in Technology, Media, and Communications at Cliff Decker Hofmeyr. Apindile, good evening and welcome. So what is this POPI Act all about? Do you mind just telling us a bit more about it?
Apologies for that. Hi, everyone. My name is Apindile. As Prudence just mentioned, I'm a Senior Associate in the TMT department at Cliff Decker. And, you know, the mention of being a senior associate sort of gives off the impression that I'm an expert in what I do. I think I just know a little bit more than, you know, the average person, but I think with the legislation such as this, all of us are learning on the job as we go along. So, you know, without wasting a lot of time, I think I'll just start by introducing what the legislation is. What we're talking about today is the Protection of Personal Information Act, which is very well known as POPI, or the Protection of POPI or POPIA, as some may like to call it. I'm trying to get my slides back. Just one moment. Prudence, can you assist?
You can share.
There we go. There we go. Perfect. There we go. Now I feel better. So you wonder why we're doing this today. For the longest of times, POPI has been a law for as long as, since November 2013, it's been a law. However, it hadn't been fully effective. It was a law, the regulator was active for quite a bit, and they were trying to resource the office in order to be in a position to start enforcing the legislation. Last year, June, the legislation then became effective and would be fully effective after a year of a grace period. And that was the 1st of July this year. So we are here today because if you don't comply with the requirements of the legislation, the regulator can then come after you. So I've been called today to come and have this brief discussion with you and just sort of give you an overview of what the legislation is. And at the end of the presentation, I will take some of the questions that may be of interest to you from my colleague, Prudence. I do want to point out that an hour is barely enough to understand the depth of this legislation. It is a relatively complex legislation. The reason it is complex is the fact that it doesn't give you all the answers. It mostly gives you the principles that you may use in your attempt to protect data. So you'll find that most of the times the regulator won't tell you, what protective measures to put in place, but tell you that you need to have appropriate, technical and organizational measures to make sure that the information that you possess is protected. So as an organization, depending on the information that you do process, that information will then inform the measures that you can put in place. So what I do want you to take away from this, more than the answers to the questions that we answer at the end, is the principles around the legislation, what personal information is, because before you can protect it, you need to know what it is, and who the role players in this whole equation are, who's responsible for what, who can do what, and how they can do it. So I need to just make sure that by the end of the presentation, you have those basics in place, and those will then assist you in your reading of the legislation, your attempt to apply it. As we've just mentioned, the legislation is now has been a law. Yes.
Excuse me, can you just maybe project your presentation in slide mode? And also there's been a few comments that there's an echo on your side. Maybe if you can project your voice a bit more.
I think I can use headphones. Let's try that. It might make a difference.
Thank you.
All right, how's that?
Much better, thanks.
Terrific. Let's try the slides. How's the presentation? How's that?
Perfect.
Okay, great. All right, so the legislation is fully effective and enforceable since the 1st of July 2021, which is why we are here today. So in the event that you fail to comply with what's required of you as an organization, the regulator can come after you, or the data subject with information processing can report you to the regulator and they can come after you, and you may be liable for some fines and penalties. Now, the question that you're asking yourself is, why should you care? So on our day-to-day lives, there are data protection implications. Personally, every day you're downloading apps and you signing up for loyalty programs. You do various things that require you to input your information, and in so doing, you're promised quite a number of things. You're promised loyalty points if you sign up for this program. You may get some discounts in the future if you wanted to travel to certain destinations. So in your getting into those engagements and arrangements, you effectively give out some of your information, and you may want to know what that provider of the loyalty program is doing information and how they're protecting it. As far as the organization is concerned, data is obviously central to any organization. And the reason it is central to an organization is the fact that data is effectively money. And we've seen in the recent past, in the last couple of years, there's been quite a bit of data breaches that we've seen. And the reason why these cyber criminals and all the rest of those who hack systems in order to access people's information, they do so, for purposes of, for instance, identity theft, and that has some implications in the sense that somebody could go and open accounts in your name and there is money that's linked to it. So you want to be very cautious and careful with what you do with your information. In the past 3 years, if you were a Liberty client, you may have woken up to an SMS that would have come in on a Saturday evening telling you about a hack that had taken place. Somebody had gotten into various systems of Liberty and they had gotten access to a significant number of clients of Liberty, and you were woken up to this SMS because systems were breached, and somebody got into the systems and they had access to quite a bit of information related to Liberty clients. And not too long ago, we also saw with Experian, if you have an account, with any credit provider, probably some of your information was there. And this was probably one of the biggest hacks we've seen in the recent past in South Africa. I think about 24 million customers whose information were accessed, and about 800,000 businesses whose information was accessed during the hack. And the effect of it was really, really devastating to the company, specifically Experian. And having experienced such a hack as a company, you run a big risk in the sense that, especially now that the legislation is fully effective, you're exposing yourself to the regulator in the sense that they will start poking into your business and start looking at the systems and measures that you've got in place in order to protect some of the information you have. One of the recent hacks we've seen also in the recent past was what happened with Nedbank. And with this, there was about 1.7 million customers whose information was accessed during the data breach. And this was also, and it's something very, very critical for any organization. So the hack happened through a third-party service provider who provided certain services to NetBank, and their systems were not secure enough, and they were hacked and they were accessed. And through that, quite a bit of information of NetBank's customers was accessed. And that obviously, that compromise on its own had some serious implications for NetBank, including reputational and cost implications. Another one that we've seen a little while ago, I think March last year, about 5.2 million guests' information really belonging to Marriott was accessed by hackers. This one, interestingly enough, it wasn't a system vulnerability problem, but it was actually an exploitation of human error. What this actually tells us is that, in the process of data protection, everybody plays a role. So as an organization, you can have all the systems you can possibly put in place, all the firewalls, and you can put in place all the policies. But if your staff complementary personnel aren't trained in the protection of data, such as, for instance, educating them and ensuring that they implement what's called a clean desk policy, for instance, all those good systems you've got in place are almost good for nothing. So everybody plays a role in data protection. You ask yourself, what are the risks for the business if there's been a data breach? I've already alluded to the fact that as an organization, you run the risk of a reputational risk, especially for somebody in the financial services industry. Because the very nature of the industry is that very sensitive data is dealt with, and if your customers cannot trust you with their personal information, their account numbers, and their money with you, then you're running a reputational risk. There may be some business interruption, because of the hack. And we've also indicated that you may need to rehaul all your systems and technologies. But I think what's even more critical here is, especially since the 1st of July, we haven't seen or heard much from the regulator as far as enforcement of the legislation is concerned. And the reason for that is very easy. They took as long as they did in order to have capacity to enforce the legislation. But the truth of the matter is, they can't go through everybody's system to make sure that everybody's compliant with the legislation. But what you do, if you happen to have a data breach or a hack, and somebody reports you, but in fact you do have some obligations under the legislation to report a data breach of your system to the regulator. You open yourself up to the regulator's scrutiny and possible fines and penalties because of that. So they may not be looking your way, but if there's a data breach and you have to report it, and they may just have to start putting into your business, literally opening up the belly of your business to the regulator. Nobody knows what they might find, but what we do know is, because the legislation is not very specific on what it is that you need to do and merely gives you the principles, nobody knows, for sure that you are compliant. Nobody, you don't walk around with a certificate saying I'm 100% compliant, for the simple fact that nobody ever really is 100% compliant. You can put in place the correct systems to make sure that, to the best of your ability, take into account, the sensitivity of the information that you're processing, to make sure that in the event that there's a hack, there is some level of protection for information, and you've got some response measures in place as well. Because you also want to respond as soon as possible and put in place the right measures to make sure that that breach or hack does not go further than it needs to. There's also the fact that there's cost implications related to that. You may be sued and you may suffer some financial losses as an organization because of the hack. What do you do in order to protect yourself? First of all, you want to be ready, right? So you don't want to be caught not expecting, right? In the sense that if you so happen to have a data breach and you have to report that to the information later because you're required to in terms of the legislation, and the regulator starts knocking on the door, looking at what systems you have in place. You want to be able to show the regulator that, the staff is properly trained and that this was through, not any particular fault of your own. You did the best that you could do. If you had any arrangements with third parties, you had proper data protection agreements in place. You had security measures that you had required your service providers to abide by. Of course, you can't go through each one of your service providers looking at their system and ensuring that they are compliant. But you want to be able to say, I've got a data protection agreement in place. You've got to be able to say, I've trained my staff. They don't leave stuff lying around. At least they've been trained not to do it. You've got the right policies in place, etc. So you want to be ready and not, be caught unexpected, and now suddenly you have to react to a data breach that you hadn't prepared for before it happened. Moving quite swiftly, the question you probably have is, who does this apply to? Who really are the role players in the cycle of data? So you've got three parties that are critical with data protection. So you've got what we call a data subject, being the person whose information you're processing. Quite unique to South African legislation is the fact that a data subject can be both a natural person, being you and I, or a juristic person, being a company. Unlike the popular GDPR, which has a data subject that's only an individual, and many other legislations throughout the world for that matter. So a data subject being both a juristic and a natural person is quite a unique thing to South Africa. There are other few examples that have a data subject being both a juristic and an individual. Another person that you look at as a role player is a responsible party. A responsible party under the legislation is the person who determines the purpose and the means of processing of data. So if as ABSIP, you're processing information of your members, you're processing information of your employees, you're processing information of your service providers, such as marketing agency, etc. You are a responsible party insofar as that information is concerned, and those would then be your data subjects whose information you're processing. And we also have what we call an operator. Now, an operator would be somebody who processes information on your behalf as a responsible party without, basically, if you have to engage somebody, say, for instance, to provide you with services, that person would be an operator for purposes of POPI. The distinction between an operator and a responsible party is not, it's not so much a question of choosing to be an operator or choosing to be a responsible party. It's more a question of function. What is the role that you're playing in the processing of information? Another question that's important is what is personal information? There's the obvious, physical data and personal proclivities, such as, your age, marital status, your name. That's obviously not, everybody knows that's personal information. And there's what I've categorized here as applied historical data. And that would be, information relating to your education, your qualification, your work, medical history, etc. There's another category, which I've named here, numbers, symbols, and contact details. I think the rest of it is quite obvious, other than things like your IP address and your geolocation. You wouldn't see that and think of it as personal information. But I think whenever you think of personal information, you must think of the criteria is this. It's defined in such a broad way under the legislation. You should look at it as any information that can be used in order to identify somebody. Now, this can be a name. Something as obvious as a name, but it can also be something as not so obvious as an IP address. If that IP address is linked to other types of information, that can also be used in order to identify you as a person. There's also things like biometric information, which the Act categorizes as what's called special personal information, which has some special requirements for its protection under the legislation. Now, as a responsible party responsible for all of this information, in your possession, such as ABSIP, you've got a database of members, you probably have a database of service providers, you've got employees, because you're responsible for all of this information, because of the industry that you play in, perhaps even your members, you want to make sure that you've got the appropriate, reasonable and organizational measures to prevent any unauthorized access to information. Now, you will recall when we started, we said, this is a principle-based legislation. You asked yourself, what is appropriate, reasonable, technical, organizational measures? It's very, very broad. But the best way to look at it is this. You look at what those measures are intended to do. These measures are intended to prevent unlawful access to data that's in your possession. So this would then, these appropriate, reasonable measures would then be informed by the type of information that you're protecting. So if you're protecting just somebody's name and surname, it's probably a poor example, but it's information, but it's not information as sensitive as medical history or somebody's criminal behavior or somebody's financial information. So the organizational and technical measures you put in place will differ depending on the information that you're protecting. They will also differ depending on, are you protecting physical records? Are you protecting electronic records? So, there's no one size fits all. Look at the information, you look at what would constitute appropriate measures, which would then, assist you prevent any unauthorized access to that information. I hope that helps. I'm trying to move through this as quickly as I can so we can take some questions as we go along. Some practical implications of the legislation, some of the things that you might want to look at are things like, and this may not be that relevant because we are under COVID, things like paper. When we still worked from the office, everybody was, you would print something and you would leave it in the printer, for instance, the whole day. You'd probably pick it up on your way home. And in that piece of paper, there might be some very sensitive information that's not for everybody's eyes. That shouldn't be accessed by everybody. However, if you leave it in the printers the whole day, you run the risk that somebody else who shouldn't have access to that information, that they may actually see what's on that piece of paper. So you want to be careful how you keep your paper records. You want to make sure that if you're keeping paper records such as files, and I'm thinking specifically here, business functions such as HR within an organization, they keep a number of files relating to employees. You want to make sure those are always under lock and key. The fact that we're working from home now might come with its own risks because you're working from home and more than yourself. Other people may have access to your laptop, for instance, because you work in an open area. Your spouse may have access to it. If you live at home, everybody else that you may happen to have access to information. So you want to try and train your employees and anybody who processes information you have, whether your service providers, subcontractors, etc., in such a way that they implement the best measures they can. And the best way to do this is put in place the appropriate policies and train anybody who processes data for you as an organization. Another thing that's quite important, as we mentioned at the beginning, if you happen to have a data breach, you want to, first of all, you want to be prepared should it happen. And best thing is that it doesn't happen, obviously, but if it does happen, you want to be prepared. You want to be prepared and have the right, what we call breach response measures in place, so that as soon as this happens, you've got this one person that it gets reported to within the organization, and that person has the right contents, the contents of the regulator if it needs to be reported, and you need to know the time stipulations in the legislation, how long you need to take in order to report a data breach to the regulator. The idea being that you want to be as prepared as you possibly can, and in the event that it happens, you've got the right measures and steps in place in order to make sure that you're not fined for having delayed reporting the breach to start with, or having implemented the correct measures to mitigate any risk that may come out of that. Now, as an organization, what you want to do, you want to first identify where you get all your information from, right? And as an organization, you get your information from your members, you get your information from your employees, you get your information from your service providers. You want to sort of, set out what types of information you receive, who has access to that information within the organization, which third parties have access to that information. If there are third parties that have access to the information, do you have the correct contracts with the correct data protection provisions in them to make sure that there's third parties that have access to information protected? You want to look at how do you process your information? Do you process it electronically? If so, what measures can you put in order to protect it? Do you process your information in hard copy? If so, what protective measures can you put in place? What protective measures do you have in place for that information? Another critical thing that you want to look at is the purpose of processing information, right? So you need to know why you're processing the information, and you need to know the justification for the processing. So the legislation requires you to have a legal basis for processing. And you'll often find that lots of people speak of, everybody's favorite is consent. Whenever somebody hears of somebody talking about processing of data, they always say, oh, did you get my consent? But I do want to point out that consent is just one of the bases for processing of information. So under the legislation, if you're processing somebody's information, you can do so on the basis of that person's consent. You can do so on the basis of an existing contract. You can do so on the basis of legislation. And all of these bases are as important as the other. So it might very well be that I'm processing your information without your consent, but I've got a right to process the information because there's a legislation that allows me to process that information. I don't know if that makes any sense. So it's almost like everybody wants to get consent for processing of information, which is good, but it's not the only basis for processing of information. Just thought I would point that out. And we've spoken at length at your storage and security of the information. You want to make sure that all that information is properly protected. But what we didn't speak of is how long you keep the data for. So the legislation allows you to keep the data for as long as it is necessary to achieve the purpose for which you collected the information. So you look at it this way: if you collecting somebody's information, the purpose of that collection is, say, I don't know, you're collecting the information to facilitate access into your building. After a certain period of time, there's almost no reason for you to keep that information because the purpose for which you collected the information has come and gone. So you should probably, at a certain point, in fact, the legislation requires you to dispose of that information and do so in such a way that it cannot be reconstructed as soon as the purpose for which you collected the information is no longer there. I think I want to stop there, and Prudence has a few questions that she will pose to me that I can try to answer, and if we still have enough time, we can take some questions from the audience.
Thank you so much, Apindile. I think there are a few questions in the Q&A, but before I do move on to the questions, there will be a poll coming up on screen. Can all the participants please participate in that poll as we are going through the questions? So I think, Apindile, the first question that came up, Given is asking, is there a way to identify who has access to my personal information? Example, my contact details, as is often the case with telemarketers.
There we go. Can you hear me?
Yes.
Okay, great. So the question is there a way to identify who has your information? Is there a database somewhere? that says, that you can go and check if this person has your information and what information they have about you. Is that the question?
Correct.
So I've seen this recently. I got an SMS recently speaking, in fact, it was an article speaking of a database that's managed by some organization of some reputable marketing agencies who are, sort of like, the organization sort of vets those organizations, those telemarketers and looks at what information they have and what they do in respect of specific people to whom they market. But as far as I know, there's not an official database. So the information regulator doesn't have a database of anybody who wants to send marketing communications, where they say before you can send any marketing information, you need to come and register here. As far as I know, there isn't such a database.
All right, thank you. And Farai is asking, may you please explain further how the symbols relate to or are associated with personal information?
I think I missed that. Is it possible for this question to sort of pop up on the screen so that I don't keep asking you to repeat?
They are in the chat box as well as the Q&A box.
Okay, but maybe you can, while I try to figure that out, maybe you can ask the question again.
All right. May you please explain further how symbols relate to or are associated to personal information?
If I hear the question is, can I explain how symbols can be personal information effectively?
Yes, how are they associated with personal information? Because I think you had a slide with symbols.
Yeah. So the idea is that it's perhaps a symbol in and of itself may not be personal information, but a symbol, combined with somebody's name or combined with an organization. I'll give an example of an employee number. If you see an employee number, on a card just lying on the street, you may not be able to take that number and link it to a person. But if you see an employee number and you see it within a certain building and on some employers' premises, you may be able to use that information to link it to a person. So the idea is that personal information is really any information that can be used on its own or in combination with other information in order to identify a particular individual, whether it's a natural or juristic person. So perhaps a symbol in and of itself, not linked with any other information, may not be enough to identify a person, but it is very possible to use that symbol to identify a particular person. And that answers the question.
I think it does. Thanks, Apindile. And Simon is asking, if I have an existing customer or a supplier database that existed before the 1st of July, do I have to go back to all the customers and suppliers to get consent so that I can continue to process their personal information going forward? Or will an existing contract between customers and suppliers be evidence of consent?
So two things that Simon speaks of there. Simon speaks of consent and he speaks of a contract. Now, you remember that I said there's the obvious one, which is consent, which is a basis for processing. But there's also other bases for processing of information, and a contract is one of them, right? So if you have a contract with a supplier and your processing is necessitated by the contract in place with the supplier, then you've got a basis for processing. However, if the processing that you're undertaking in respect of that particular supplier is not necessitated by the contract in place with that supplier, for instance, in addition to whatever relationship you have with the supplier, you want to send marketing communications. For that particular processing, you may need consent. The idea being this: if what you are doing with the information relates to the contract in place with the supplier, then you're fine. But if your processing of that supplier's information or service provider has nothing to do with the contract in place, as of the 1st of July, you have to have a basis for doing that. And that may very well be consent, and that may very well be an updated contract or an addendum to the existing contract with the supplier to then take into account the new form of processing of that supplier's information.
Thanks, Apindile. And there's a question from Simon. Does POPI only apply to data processed in South Africa? So if we use Microsoft 365 for emails, SharePoint, Outlook, does that mean that the data is processed, stored in the US, and therefore POPI doesn't apply?
So you always want to trace the following things. You always want to look at if as ABSIP as a responsible party, you're using third-party systems, right? So you're processing South Africans information relating to South Africans, and you happen to subscribe for a product like Microsoft 365. And because of that, your information happens to be processed overseas. POPI will still apply to that information because it's information relating to South Africans. However, before you can even have that information, sent overseas for purposes of your service providers processing, which is Microsoft, you need to make sure that you comply with the legislation, which is Section 72 of the legislation, which speaks to transfer of personal information across border. So there are some specific requirements that apply to your processing of South Africans' data overseas. So if you're transferring data to your service providers that are based overseas, you need to comply with Section 72.
Great. So all of these databases and the Act are all sort of interlinked in one way or the other. There's a question from Rudzani. What immediate security measures do online stores or SMEs selling goods online need to have in order to comply with POPI?
I believe the question is speaking to specific security measures they need to have in place.
Yeah.
Yeah, that might be tricky for me, but you must just remember the principle is this. Whatever principles you put in place need to be principles that are appropriate, taking into account the information that you're processing. Now, as an attorney, it'll be very difficult for me to, in fact, I would mislead you if I were to start telling you what protective measures, security measures you need to put in place in order to protect that information. You might have to engage a third party to assist, a service provider to assist you with that.
Alrighty, and Itumeling is asking, does the legislation require companies to disclosure to what extent the affected client's information has been exposed? Example, would Nedbank have to notify the clients whose monies have been impacted?
I think the question is speaking to a data breach. I think the question is, and maybe you said it's Rutani, hey?
Itumeling.
Oh, Itumeling, apologies. Maybe Itumeling can just confirm. So I think the question is, if there's been a data breach, does that have to be disclosed? Is that the question?
Yes.
Yes, the data breach has to be disclosed to the information regulator and under certain circumstances to the data subject.
Can anonymous? Yes, go ahead.
I think what I also just wanted to mention was, it's not just when there's been actual, it's not only when there's been actual breaches of data. So the legislation specifically said, where there are reasonable grounds to believe that personal information of a data subject has been accessed or acquired by an unauthorized person, the responsible party needs to first inform the regulator, the information regulator body established in terms of Section 9 of the Act, in order to ensure compliance with the legislation, as well as then the data subject, taking into account the circumstances under which that has to happen under the legislation. But yes, you do have to report data breaches to the information regulator.
Alrighty. And I think there's some attendees here that are business owners. Kabel is asking that He runs a small business and has 3 employees. And POPI requires organizations to have an information officer and a deputy as well. How do I go about this?
I don't know that you're strictly required to have a deputy, right? But you may appoint a deputy, but you are required to have an information regulator. The information regulator actually has a portal that's meant to exactly address that for your registration of your information regulator. The default position is that the head of the organization is the information regulator, which you need to register, but that position can be delegated to somebody else by the head of the organization. There's a portal. If you go to the information regulator's website, and we'll try and post that, if I can do that, I'll try and get the link to the portal on the information regulator's website that you can follow in order to register your information officer. You may need, depending on the size of the organization, you may want to register deputy information officers, depending on the size of the organization. But if you're a small organization, I don't see why you would need to have an information officer, deputy information officer, or deputy information officers to assist you with the processing of, with the functioning of that office, of the information office. What I do want to mention also is, because everybody has been trying to register information officers on that platform since since before the 1st of July, in the past week or so, the portal has been down. There's a notice if you go on the website which says, they apologize for any inconvenience. The portal will be up and running as soon as possible, which would make sense because everybody is trying to register the information regulators right now. But there is another option, another alternative to registering on the portal itself. There is a manual process where you can complete the forms on the website and you can email them to the information regulator. All the details on the website.
All right, and Given has another question. In terms of the POPI Act, what recourse do I have if I feel like my information is compromised by a certain organization?
I think this is speaking to the penalties I spoke of and what you can as a data subject whose information has been compromised.
Yep.
You can report that to the information regulator. Also, if you go to their website, the contact details are there. In the event that you feel that somebody has processed your information in contravention of the legislation, report that to the information regulator. They've got some investigative powers, and they can, pass fines, and people can actually be imprisoned for having processed your information in contravention of the legislation. But the place to start is to report such to the information regulator using the information on the website.
All right, and Siphelele is asking, how would the regulator determine whether the policies in place within the organization are sufficient post a data breach?
You're asking what if they look at your policies? So there's been a breach, you've reported it, and they start probing in your business, and they want to see what you have or do not have, and whether or not it's sufficient. I think, and you didn't ask me this question, but I think they'll first look at your systems, right? Heck did happen, but what did you do wrong? Past that, and you did nothing wrong, then they go further and look at, have you conducted any training in respect of your staff? Do you have the correct policies in place? But the simple question is this: when they look at your policies, they would look at whether or not the policies do meet the requirements of the legislation, right? So for instance, there isn't specifically a requirement so the legislation doesn't say draft a policy and put it on your website, but it does say you do need to tell your data subjects what information of theirs you're processing and how you're processing it, and generally what activities do you do in respect of any information that you have in the system, what categories of information you have, so that your data subjects do know that. So if somebody visits your website, let's say you've got a website and you're selling stuff and somebody visits your website, you do want to make sure you know certain information. That's required by the legislation. So when they look at your policy, you look at what it is that's required of you by the legislation. And if you say you are doing that by having a policy in place, remember what we said, the legislation doesn't tell you the how, it tells you what to do. It says you need to tell opinion that you're processing this information of these. This is what you're doing with the information. This is who you're sharing that information, but it doesn't tell you how to do it. So you can choose to say you're going to have consents with each data subject whose information processing and write them a long love letter and say, this is your information, this is what I'm doing with it, this is how I'm doing it, this is who I'm sharing it with. And that will be sufficient. But a much more effective way to do that is having a policy in place, which you publish on your website to make sure that everybody that visits your website can see what information you process and what you are doing with that information. So for them to determine whether or not your policy is correct or it meets the requirements, they'll look at the legislation. Look at whether or not that policy achieves that.
All righty. Sure, Apindile, there's so many questions here.
I'm gonna try and answer as quickly as I can. So.
All right, thanks. Katazile is asking, from the simplicity of just an SMS and a call while contacting someone, do you need their consent?
From that?
So when contacting someone via an SMS or a call, do you need their consent?
Contacting them for what? For marketing purposes?
Just as, for example, if I'm giving you a call or I'm sending you a text.
No, that doesn't. That's personal use, and the Act is not intended to regulate that.
Right, and there's another
that
question.
falls within the exclusions. For more of those exclusions, one can go and look at Section 6 of the legislation. Section 6.
Okay. And there is another question. Nelly is asking, in respect of historical profile or a criminal record background. Sorry, in respect of a historical profile or criminal record background search of an individual, how will it affect prospective employers in this regard?
The question is, if you are a prospective employer and you're doing background searches in respect of the potential employees, the question is, how will that affect those prospective employers?
Yes, because now a criminal record is some form of data
special personal information. Yeah. So there's a distinction here between, it's a very technical one, probably unnecessary. So there's a distinction between just criminal history, and there's also what we call somebody's ongoing convictions. If somebody has been accused of a crime and they're currently going through the law enforcement processes to determine whether or not the person is in fact guilty of the crime, it's actually the latter that's considered what's called special personal information. But I would just make that distinction. But insofar as criminal history is concerned, I think let's assume that it's all special personal information. If you're doing all of those searches, I would like to actually distinguish between two things. Processing before the employment. So any processing that happens past the employment, once there's been a contract of employment in place, all of the processing will take place in terms of the employment contract. So no consent necessary there. But what makes those background searches and criminal record searches very, very important, and I'm glad you asked the question, the fact that they happen before there's actually a contract in place, which means at that point, there isn't a basis for you to process information. And I'm assuming that there's no law that allows you to process information, because I can't think of one as an employer, which means at that point, if you're doing any background checks on any prospective employee, you need to get their consent to do that. So how it affects you is, as of the 1st of July, you would then need to get consent in order to process, background checks and criminal records and all the rest of that in respect of employee consent.
Yeah, sure. Kabelo is asking if I invite you on LinkedIn and you accept my request, does it mean that you give me consent to see your qualifications and work status? And with regards to people on WhatsApp groups created before the 1st of July.
So one has to distinguish between two things. So, and one would have seen, a million consents, if you don't like to be part of this group anymore, you can leave, and all the rest of that. So one is to just distinguish, and it's a very complex question to look at. But I think the principles are these. If it's a WhatsApp group between friends, there really is no need for consent as far as that's concerned, because it's for personal use. However, if you're using WhatsApp for business, that's a different story. You want to make sure that you've got a basis for processing of that information. One must also remember you are using the platform as the employer, and this is a third-party platform, which means the information that's being processed within the platform or the group that you've created in respect of your service providers or your employees or whatever is owned by a third party. They may have their own policies that may not necessarily be in line with our local legislation in order to protect those participants' information. So under those circumstances, if it's WhatsApp for business, different rules apply, but if it's personal, then there's no need for consent. As far as somebody inviting you on LinkedIn and you checking out their profile, I think that's perfectly fine. Remember, this person has put up their profiles and qualifications and all of that on their profile for everybody to see. It would be silly for them to say, "Ooh, look at you, you're in our profile, I'm suing you." It won't work. In any event, it will probably fall within what was mentioned earlier, that it would all be personal use. It wouldn't be for business, and therefore different rules apply. And it might actually fall within those exclusions. But one would have to think about that. But I wouldn't stress.
All right, understood. I think that's very informative. There's been quite a number of questions regarding the WhatsApp groups that have been going around. There's a few questions as well from Samu, and I think it's Msali around who do they go to regarding developing a data privacy policy or a consent form?
Well, I can help you, but if you're developing a policy or you probably can do it, because at the end of the day, all of these things have to say stuff that you already know. If you wanting, for me to consent to you processing my information, say you want to give me employment, you want to consider me as the candidate, and you want to do background checks, for instance, like we just mentioned, all that your form is to say is that, you're applying for employment with me, and in order for me to consider you for this, I need to do background checks, background checks including your criminal records. I need to do psychometric tests and all that. It's literally all there. It's stuff that you already know. All that it means is you must just get permission to do so, because at that particular point, you don't have a basis for processing of that information. And as for the policy, it's also quite a simple thing, but you probably want to have somebody that's got a grasp of what the legislation actually says and what it requires, so that your policies actually are worth the paper they're written on, that they are in fact compliant with what's required under the legislation. So I'd say contact your attorney. That can help you, like I said.
And if people don't have an attorney at their disposal, how should they go about it?
Well, either they do it themselves, but you run the risk of not doing it right, or ask a friend. But the regulator won't help you. They won't draft your policies for you. It's your responsibility as a processor of information to make sure that you process the information into legislation. But there's not and I think that's what the question is probably asking. There's not like a legal assistance thing that the regulator has in order to help people who cannot do what's needed by the legislation to comply. Ask a friend, do it yourself, or ask a lawyer. But chances are somebody will be willing to help.
All right, thanks, Apindile. Edna is asking, with respect to processing information for purposes of performing under a contract, would inserting a detailed clause in a contract informing the other party how their information will be used, which the client subsequently signs, would that constitute as consent in terms of POPI?
So the question is, there's an existing contract in place and you process it in terms of that existing contract. The person wants to know, do they need to add a consent clause in that contract?
Yes.
Like I mentioned earlier, if your processing is necessitated by that contract in place, then there's no need to get consent. I don't know if that makes any sense. It's only if you need to process the information for something that's not covered in the contract, or your processing is not related to the contract. So you're not processing because there's a contract in place. You're not fulfilling your obligations under the contract. Then you need consent. So if all that processing is in terms of the contract necessitated by the contract, then there's no need for that consent. But your contract, I do want to mention this, but to the best of your ability, your contract has to be clear enough. You have to clearly say, this is what I will do with your information. I'm sharing your information with these third parties, etc.
All right, thank you. I think we've covered most of the questions. There's one last one from Sfiso. What is the role of legal practitioners when it comes to POPI?
Because that's all we have from the question, I think I'll try and answer as broadly as I possibly can. I don't think there's strictly a role that applies to, there's not a section in POPI that says all legal practitioners must comply with this. However, I will mention that generally as a legal practitioner, when it comes to your role in the process, remember the parties I made mention of at the beginning, the responsible party, the data subject and the operator. Most of the times, even if you're processing information from your client, the instinct is to say, if a client is instructing you to execute instruction 1, 2, 3, you are an operator because you're processing that information on behalf of the client, and that's not correct, right? So as an attorney, as a firm of attorney, because of the nature of your role and the responsibility and the obligations you have in respect of that information and the instruction, take into account the fact that you determine the means of processing, what you do with the information. All that the client is doing is instruct you. So because of the role and function that you play, you are what we call a responsible party. That's really all that I would say the legislation says as far as legal practitioners are concerned, which means as a responsible party, your obligations are much higher than those of an operator. In fact, the buck starts and stops with you. If something happens in respect of the information in your possession, the regulator will come for you, and you have to comply with all the obligations of a responsible party as a legal practitioner in terms of the legislation.
All righty. Thank you so much, Apindile, for that informative session and for answering all our questions. It is very much appreciated, and I hope everyone's questions have been answered. And I think it gives them comfort as well to understand the POPI Act at a much broader level. And yeah, it's been very informative. Thank you so much. There has been another poll that came up. It will be highly appreciated if everyone can just answer that poll. It's a very quick one. And yeah, that will be all for the session. Thank you so much, Apindile, for the time that you've came to spend with us, and much appreciated. There has been a question about the link for the information officer. If you can just please post it in here in the chat room.
Okay, as long as you don't end the meeting, I'll try and get that and post in chat. But I do want to just mention again that the portal has been down for quite a while. So either you try it and it works. If it doesn't work, you can do it manually and just send them an email, completed forms.
All right, awesome. Thanks everyone for joining us tonight and for asking all your questions. And I hope this session has been very informative for everyone. And thank you, Apindile, once more. for gracing us with your presence tonight and giving us as much information as we needed. Thank you so much, everyone, and have a great evening.